the Kenya annual extractive.
Untapped reservoirs of oil within the shared continental shelf of this Southern Sea, and have begun exploration for the same, including conducting seismic activities, which have led to some adverse environmental effects, as well as an oil spill, as you can imagine, which have also led to some effects to the economic activities of the coastal states. These are coastal states. So the state of Sokovia has taken Himia to the ICJ to answer for some environmental responsibility and liability issues. Just a quick briefing on the judges. Judges, both applicant and respondent have 30 minutes each. They will introduce themselves, their names, and give us a rundown of the time that they will use. Applicants begin, and judges, you're most free to ask questions. Feel free to interrupt the applicants, the counsels.
And their particulars. Maybe we start from this side.
Your Excellencies, it's a great honor for the respondent to appear before this honorable court. I am Chitindi Marvelous. Appearing with me is Agent Swale Hemed Wengo. Chitindi Marvelous.
Excuse me, which country would you be representing?
We're representing the respondent state of Himia.
Himia.
If it pleases this court, Kukebe Kevin is my name. I appear alongside my co-agent, Eva Maria. Your Excellencies, we represent the applicant state, the state of Sokovia. Thank you, Your Excellencies. We get started with the counsel for the applicants. Please proceed. Thank you, Your Excellencies. Good morning. For the record, once again, Kokebi Kevin is my name. Your Excellencies, I, alongside Eva Maria, do represent the applicant state. Your Excellencies, in regard to allocation of time, I'll be spending the first 14 minutes to argue the first two issues in our memorial. That is, whether this honorable court has jurisdiction to hear this matter and entertain it for that purpose. The second issue that I'll be tackling is whether the state of Himia is liable for the effects of the exploration activities that has taken place in their jurisdiction, and specifically the deaths of the sea turtles, the hawksbill-tipped sea turtles. Your Excellency, the last two issues in which my colleague will be spending the next 10 minutes to tackle is whether the agreement between the state of Himia, that's the respondent state, and that of Nabotia, the agreement that they have, the unitization agreement, whether it's valid. Your Excellencies, the last issue will be on the issue of reparation, compensation. Your Excellencies, if that explains the nature of our submissions, I beg to proceed with your kind permission. The last 6 minutes we'll be preserving for rebuttals. Your Excellencies, what is before you today is an issue of jurisdiction, yes. But before we answer to the question on jurisdiction, the clarion call that not only is called to this court, but equally to the general state members around the globe, is the question on security to the ecosystem, ecological security. Your Excellencies, if I lay it bare as it should be, should a state, civilized so to speak, proceed on a path of self-destruction? Should that be the case? Your Excellencies, not only for its nationals, but equally to its neighboring states. The question that was asked to the young lawyer, what is the duty to your neighbor? Who is this neighbor that you're talking about? It is the applicant state. And we have suffered adversely from the actions of the respondent company, state-owned company that has proceeded with the extraction process. Your Excellencies, these are not my words. These are words by your very good brother. And Justice for Remedies are sitting there. Then it was a dissenting opinion, but over time it has gained efficacy. Your Excellencies, in his dissenting opinion, in the adversary opinion, in the threat and the legality of use of nuclear weapons, then he said that the state should not set on a path of self-destruction. This very position was subsequently echoed in 2010 in the partner's case. Why then should the respondent be left to run on a flooring to set us, not only the nationals, but equally the applicant state, in a path that is self-destroying? That said, Your Excellencies, being my opening remark, does this court have the jurisdiction? It is the applicant's case and submission, and we'll be inviting this court to find as such that indeed this court has jurisdiction. The question on jurisdiction, Your Excellencies, is not a question of fact. It is a legal question. It is sacrosanct, and one cannot will facts to wield away the jurisdiction of this court. Your Excellencies, Article 36 of the ICJ statute gives this court the mandate on what it can handle. Article 36, Your Excellencies, and I'll only speak to two limbs of that particular article. That is Article 36, paragraphs 2. Your Excellencies, in that article, the question that I asked is, one, has there been an international obligation which has been breached, which then calls for this court's action? There has been one. And we'll be proceeding to do exactly to show this court that there has been an obligation, an international obligation, which has been breached. The next question is on reparation. Your Excellencies, my co-agent will be talking on the concept of polluter pay. That is equally before this court. Your Excellencies, the main convention then that is in contention today is the Convention of Biological Diversity. Article 1 on the Convention of Biological Diversity speaks to the objective of that very convention. What is then the objective? The objective is preservation of the ecosystem. That is the very reason why you're before this court and you're asking this court, should the respondent state then set us on a self-destructive path? Your Excellencies, Article 2 of the Convention of Biological Diversity then defines what is biological diversity. It is at various issues. One, the very Sydney Sea that we're talking about forms the biological diversity. The hawksbill turtles, sad to say, the 9 hawksbill turtles, in which are the beauty of that very sea. Your Excellencies, from the fact pattern, specifically, if you look at the fact pattern, Your Excellencies, and that is fact paragraph 2, there are 2. Your Excellencies, you learn that the applicant state, that is Sokovia, heavily relies on tourism as its economic backbone. And the death of those sea turtles is defined as being catastrophic, as per paragraph, that is paragraph 12, if I'm not wrong, Your Excellency, of the fact pattern. Does this court have jurisdiction? That's a question that we'll be still asking. Yes, it does. Having looked at the objective of the CPD, having looked at the definition of biological diversity, and when you look further into Article 27, Your Excellency, paragraph 3, when is this court then invited to adjudicate on a matter? This court is called on to adjudicate on a matter when the parties before you today have tried to solve this matter in another sphere or in another platform. Have they done that? Your Excellencies, it is the applicant's submission that that has been done, and that can be attested to having a look at paragraph 16. There has been negotiations which have failed. Your Excellencies, besides that, the respondent continues in her exploration. An exploration that when you look at paragraphs 11, 12, Your Excellencies, you will learn that there was an explosion, and from that particular explosion, Your Excellencies, there has been a spillage following the Sparrowjack oil ridge. That was a wildcat that was being drilled by the respondent state under a state-owned corporation. Why are we before this court? We are before this court for the fear of what has so far happened. Your Excellencies, in the Kofu Channels case, if I may, the question on jurisdiction was again discussed. When does this court have jurisdiction? And how do parties then consent to it? Your Excellencies, one thing that comes out clear from the Kofu Channels case, that is between the state of the United Kingdom versus the state of Albania. The International Court of Justice, that is 1948, stated then that member states need not express consent to the court jurisdiction in advance or in any particular form. Your Excellencies, at paragraphs 1, both the respondent state and the applicant state are party to the CPD and have acceded to the jurisdiction of this court. They will be arguing, Your Excellencies, that without the state of Nabotia, then this court has the jurisdiction. We argue not.
Sir, excuse me, may I pause you then?
Yes, Your Excellency.
So my question to you will be, why do you think the Republic of Nabotia shouldn't be joined in this matter to begin with?
Thank you, Your Excellency, for the question. Why does the applicant state feel that the state of Nabotia is not necessarily party herein? The acts that have caused us to come before this court, Your Excellency, looking at, that is paragraph 11, Your Excellency, the acts that were committed by the respondent state. That is number one. And by its own national corporation. Where were they committed? In their own exclusive economic zone. Where was it committed? 3 kilometers away from our economic zone. That is our client. Your Excellencies, can it be said then that we should be joining a state that is not before this party? It will be sad to litigate for a party that is not before us, Your Excellencies. The acts solely were in the jurisdiction of the respondent state.
Okay, a follow-up question would be then, why was the Republic of Nabotia involved in the dispute resolution?
They will be arguing, Your Excellencies, that there is a unitization agreement to which the state of Himia and Nabotia entered into so far as exploration is concerned. That unitization agreement is a bilateral agreement between Nabotia and Himia. We are not party to that. And that is why we are not willing to invoke the same. In any case, Your Excellencies, we will only be invoking that if we were party to it. We are not. Secondly, Your Excellencies, in that unitization agreement, the question that is before this court, and probably will be asking, what is the shared resource between the applicant state and the respondent state? The shared resource is the Sydney Sea, not the proceeds of the exploration. The proceeds will be solely between, the sharing of the proceeds is between Nabotia and Himia. And that is why it is sad that we don't want to discuss and litigate on behalf of a state, not before this court. Your Excellencies, in any case, be as it may, that this court finds otherwise, which we beg this court not to find so, because we have set on a path of self-destruction. Should we continue in that process? Simply because this respondent state has a right to develop. Your Excellencies, that question will be answered shortly. That said, Your Excellency, we urge this court and invite this court to find that it has jurisdiction to entertain this matter without enjoining the state of Nabotia. If the respondent feels that indeed they are slapped with sanctions to pay for the reparations and feel that Nabotia should help them, that is their private agreement and is also expressed by the unitization agreement. So they can pay for what this court will find, then they can seek on how to sort out that as between Nabotia and the state of Himia. Your Excellencies, that pushes me to the next issue. Your Excellencies, did the respondent state do due diligence? Was there an obligation that has been breached? Yes, there was an obligation that was breached. Your Excellencies, take cognizance of paragraph 11, where we state that the acts of exploration are only 3 kilometers away from the applicant state. Take cognizance again, Your Excellencies, that it is on a shared resource, natural resource. Cognizance again should be taken to the fact that the applicant state, just as the respondent state, rests their economic backbone on tourism. They're only trying to advance the economic muscle. But then should we continue that very path? If already their acts is already having a diverse effect to the environment. Your Excellencies, in the 12 smelters case, the question of transboundary harm kicks in. Was it foreseen, could it be foreseen that indeed the 3 kilometers variance was just close that will then probably lead to the respondent thinking that there might be an issue of transboundary harm? In the 12 semester case, the question is answered that if it is foreseeable, then you have to take actions to prevent the same. There was an obligation, Your Excellencies, not only to their nations, but equally to the applicant state. Your Excellencies, the effects of pollution we cannot come back from it easily. It will take us time. We can just suppose that with the recent spillage, the BP spillage, the Gulf, what has happened? To date, we still feel its effect. And the same effect is seen when we talk of the 9 turtles having been found dead. That is a fact pattern paragraph 13. Your Excellencies, in the Gapsikovo case, Judge Huber states that, and following Article 13 on the wrongful acts of state, on the Convention on Wrongful Acts of a State, he says that an obligation will arise if if a state is party to the convention. Is the respondent state party to the convention? Yes, it's party to the CBD. Is there an obligation raised? There is an obligation. To that end, their continued exploration and the subsequent oil spill indeed then calls for that obligation. Your Excellencies, they will be arguing that there was no need to conduct an environmental impact assessment. And they will be telling this court that there was somehow an environmental impact assessment that was conducted, but then it was not thorough. Your Excellencies, we are talking about generations today and generations after. Should we then allow negligence to take and drive the cause of development? Your Excellencies, once again, in the case of Gapsikovo and in the Parsons case, the position is let us balance. We know and understand that they have a right. They'll be invoking the code, the CBD. That is the Convention of Biological Diversity, that they have a right to develop. But when does that right become, is that right absolute? Then we'll not be having a Sydney to talk about. Then we'll not be having a state of Himia to even talk about. Not only is the state of Himia, but even the applicant state. Your Excellencies, may I invoke the emotions of this court. I know that emotions have no place in law. But then, what if that is the sole thing that anchors our very existence? Your Excellencies, the principles of environmental law have grown leaps and bounds, and now they're treated as part of customary international law. To that end, the respondent state is liable and should indeed be found to be liable. This court, we pray, has jurisdiction.
Thank you very much. May I draw your attention to paragraph 15
Yes, Your
of the
Excellency.
submission? I quote, the unitization agreement signed on the 5th of December 2014 between the states of Nabotia and Imaya duly qualifies that damages and liability shall be shared between the two contracting parties in the event of an oil spill or damage of a transboundary nature.
Yes.
So, does that not follow that those two parties, based on that agreement, ought to be joined before this honorable court?
Thank you, Your Excellencies. No, they shouldn't be joined. Why do we proceed on that trajectory, Your Excellency? There are two parties to an agreement which we are not privy to. That's number one. So we cannot even purport to proceed and litigate on an agreement that we are not privy to. That's one. Two, Your Excellencies, is that as they act in the unitization agreement, they act as agent and principal of the other. And from where we stand as the applicant state, Your Excellencies, and probably if you allow me to analogize, we know not the extent of who has the largest share of the oil exploration. That can only be told by an expert, and I not want to submit from the bar. And Your Excellency, that said, it might be the state of Himia, it might be the state of Nabotia, but our sole concern goes to where was the locus? The locus was in the respondent state, and that is why we opt to go for the respondent state, because that is where the actions occurred. And if the respondent state feel that indeed the other party, that is Nabotia, should be before this court, Your Excellencies, that is an issue of a third party, of which they'll be seeking indemnity. We don't seek indemnity, Your Excellency, from our point of view.
We're asking for reparation.
We're asking for reparation from the respondent states where the acts actually occurred. It did not occur in Nabotia. The actions were within the jurisdiction of the respondent state. Your Excellencies, if there will be no any other further question from the bench, I can see the President of the court indicating that probably there will be something from that end. Thank you very much, Mr. President and Your Excellencies. That will be the end of my submission until I come to rebut. If there are any, I'll seek to yield the floor to my co-agent.
Please proceed.
Good morning once again, Your Excellencies. As my co-agent earlier introduced me, my name is Eva Maria Anyango. And for purposes of my submissions, I will be addressing you on the third and the fourth issue, being whether the unitization agreement between the respondent state and Nabotia is valid, and finally on matters concerning compensation. I will start on the validity of the agreement. Your Excellencies, we do humbly submit that the oil spill that occurred as a result of the exploitation activities of the respondents under the unitization agreement amounts to a gross violation of international environmental law, which is the obligation not to cause transboundary harm. And for that reason, any activities under the unitization agreement should be suspended and not carried out anymore. As Council, my colleague earlier said, and I will reiterate, we do acknowledge, and the respondents rightfully can argue, that they have a right to development. However, this right is not absolute. It has to be balanced with their obligations under international environmental law to ensure that they do not cause transboundary harm. Our point of reference is Article 194 of the United Nations Convention on the Law of the Sea. It lays down the principle of the obligation not to cause transboundary harm. This is a principle that has also been adopted in decisions of arbitral tribunals, international arbitral tribunals, and the International Court of Justice. And in particular, I would like to point out the decision of the arbitral tribunal in the Trail Smelter case, which was between the United States and Canada. When you look at facts of this case, they do present similar situation as the one that we have before you today. Just like in that case, we had two states. We had the state of Canada, in which a company was emitting gases that polluted the environment and went even into the boundaries of the United States. And as a result, the United States sought reparations for the damages that occurred subsequently. And so in this case, we also have a state in whose territory there is exploitation activities that resulted in a catastrophic oil spill, which has affected us directly and has therefore caused transboundary harm. And so we do invite this court to find that the oil spill, which is a consequence of their exploitation activities, was a violation of their obligation not to cause transboundary harm. Your Excellencies, the oil spill has also violated the obligation to observe the precautionary principle, which is enshrined in Principle 15 of the Rio Declaration. And this obligation goes along and is blended in together with the obligation to carry out a thorough environmental impact assessment. Your Excellencies, when we look at the compromise, we are told under paragraph 10, Your Excellencies, that there was no thorough environmental impact assessment in the last sentence of the said paragraph. And Your Excellencies, as we know, the respondents will argue that there is no direct link between the death of the 9 hawksbill turtles and the oil spill that occurred. However, Your Excellencies, is it a coincidence that 22 days after an oil spill that was catastrophic, 9 hawksbill turtles died? Your Excellencies, I leave that question to you because it is for you to deduce whether it is a coincidence or not. However, we would also argue that this presents some level of scientific uncertainty, and therefore it places a greater obligation on the respondent state to carry out a thorough environmental impact assessment, as was stated in the pulp mills case on the River Uruguay, in which the court established that an environmental impact assessment is particularly mandatory where activities of a state are likely to cause transboundary harm and, for that matter, in a shared resource. Your Excellencies, as my co-counsel stated in the beginning, the state of Sarkovia entirely depends on this resource for their economic well-being. And so what we have at stake is the economy of an entire nation and its future generation. And so we call upon this court to find that any activities under the unitization agreement should be suspended for lack of carrying out a thorough environmental impact assessment in order to establish with certainty any possible effects it may have on the environment. With that, Your Excellencies, and if you have no questions, I will proceed to address the question on compensation. Thank you, Your Excellencies. Thank you. So, on matters of compensation, we do argue that the polluter pay principle is very clear, that a state must take responsibility for any damages that they cause to another state. Your Excellencies, I would like to draw your attention to the Chozo factory case between Germany and Poland. Your Excellencies, this was a case before the Permanent Court of International Justice. In this case, Germany gave up or surrendered some of its rights to certain properties to the state of Poland on condition that the state of Poland will not in any way violate or give these rights to any or forfeit these rights to any other person. But subsequently, they did so. And Germany incurred several losses. And Your Excellencies, they approached the court for reparation, and this was granted. In the same way, Your Excellencies, the court found that since the actions of Poland directly contributed to major losses to the state of Germany, they were responsible for making adequate reparations. Your Excellencies, the question that we are then to ask ourselves is where and who were responsible for these actions. In the Trail Smelter case, the arbitral tribunal established that it is the responsibility of a state to make sure that any activities of individuals within their jurisdiction do not in any way affect another state. Your Excellencies, in the same way, it was the responsibility of Himmaya to ensure that the activities of the company in question did not affect other states as well. And as we read from the fact sheet, Your Honor, Your Excellencies, we do find that this company went ahead to drill an oil well when they knew very well that they did not have the required experience and expertise to carry out these duties. And so it shows a great level of negligence and lack of responsibility on their part. And therefore, they do not have any other option but to make reparations and compensations for the damages caused. And so, Your Excellencies, unless you have any questions, I will invite them.
Okay. A quick one. Do you have any case law to back up what you're arguing for? So, for instance, is there any case law existing already showing the unitization agreement between two countries? And something similar to what you're arguing for right now, that we have jurisdiction without involving Abotia. Do you have anything to that effect to share with us?
You have jurisdiction?
Yes.
Yes, Your Excellencies, we have the Lockerbie case.
Okay.
This was between Libya and the UK, in which they had an agreement under the Montreal Convention. And in this case, there was a requirement under Article 14 of the Montreal Convention that in the event that there were negotiations and mediation but they failed, then they would submit to the court's jurisdiction to resolve the dispute. In the same way, Your Excellencies, in our case, under Article 27.3 of the CBD, which is majorly the convention governing the issue in question, it is a provision that in the event that parties negotiate and they fail to resolve the dispute, then they resort to the International Court of Justice.
But did the Republic of Nabotia agree to this?
Your Excellencies, they are party to the Convention on Biological Diversity, but the aspect of consent on their part is not present. And parties, there is a precondition that they have to give consent to be enjoined.
Exactly.
Your Excellencies, so as I conclude, our prayers before this court My time is over, Your Excellencies. I ask for 1 minute to conclude on my prayers.
Yes, please conclude.
Most obliged, thank you. So we do humbly implore this court to find that it has jurisdiction to hear and determine the matter in question. Secondly, that the respondent state did not exercise due diligence in carrying out their obligations, and that the unitization agreement in question is invalid and its activities should be suspended. And finally, that the respondent state should make compensation to the applicant state. With that, we rest our case, Your Excellencies.
Thank you very much indeed.
Thank you.
Let's have the response, please.
Mr. President, Your Excellency, once again, my name is Chitindi Marvelous. With the 30 minutes that we've been given, I will, in the next 10 minutes, respond to the applicant's submission in regards to issue 1, and my co-agent shall use the next 20 minutes in responding to issue 2 and issue 3 as raised by the applicant. Your Excellency, subject to the convenience of this honorable court, I'd like to proceed. Your Excellency, the respondent are not contesting the jurisdiction of this honorable court in regards to the state of Sokovia and Himia. However, the preliminary objection that we raised before this honorable court is that this honorable court shall not have the jurisdiction if the state of Nabotia is not enjoined to this matter, based on the unitization agreement that we have with the state of Nabotia. And Your Excellency, to clarify, agent of the applicant had submitted before this honorable court that the state of Nabotia has not consented to the jurisdiction of this honorable court. However, Your Excellency, I would like to draw the attention of this honorable court to paragraph 6 of the facts, which clearly shows that the state of Nabotia has consented to the jurisdiction of this honorable court in regards to the Convention on Biodiversity, pursuant to Article 27. With this, Your Excellency, would like to draw a roadmap on how the respondent shall argue before this honorable court in responding to the applicant's submission. Your Excellency, on the first hit, the respondent shall submit before this honorable court, or rather shall give reasons as to why the state of Nabotia should be joined to this matter. And secondly, Your Excellency, that the unitization agreement is valid and therefore the state of Nabotia should be joined to this matter. If I may proceed to the first hit, Your Excellency, indeed, this honorable court has the jurisdiction to handle this matter pursuant to Article 36 of the International Court of Justice, which gives this honorable court jurisdiction to handle contentious cases and give advisory opinion. Your Excellency, for a state to be parties to a contentious case, such as this one, in persuading this honorable court, the respondent would like to rely on the Handbook on Accepting the Jurisdiction of this honorable court, Model Clause of 2014 at page 34, which is to the effect that for a state to be parties to a contentious case, it must have access and it must have consented to the jurisdiction of this honorable court. Your Excellency, this drives me to the first criteria in regards to access. Your Excellency, it is the respondent's humble submission that Article 35 of the International Court of Justice statute provides that all members that are parties to the International Court of Justice have access to this honorable court. And furthermore, Your Excellency, Article 93 of the United Nations Charter of 1945 is also to the effect that all members of the United Nations are ipso facto parties to the International Court of Justice. And Your Excellency, driving this honorable court's attention to paragraph 4 of the facts, it is clear that the state of Himia, Sokovia, and Nabotia are members of the United Nations. And therefore, Your Excellency, it is the respondent's humble submission that the state of Himia, Sokovia, and Nabotia have access to this honorable court. This drives me to the second criteria in regards to consent. Your Excellency, it is the respondent's argument that the jurisdiction of this honorable court is based on the consent of the state to which it is open. As we have established that indeed the 3 states have access to this honorable court. Article 36, Clause 2 of the International Court of Justice statute provides for ways in which a state may consent to the jurisdiction of this honorable court. And Your Excellency, it is through a unilateral declaration, and secondly, through treaties or convention, thirdly, through special agreements or forum prorogatum. And Your Excellency, as seen under paragraph 4 of the facts, it is clear that the state of Himia and Sakovia have unconditionally accepted the jurisdiction of this Honorable Court, and of which we are aware that indeed the state of Nabotia has not consented to the jurisdiction of this Honorable Court as compulsory. However, Your Excellency, as I earlier stated, a state may express its consent through a convention or a treaty. And as seen, relying on paragraph 6 of the facts, it is clear, Your Excellency, that the state of Nabotia has consented to the jurisdiction of this Honorable Court in regards to Article 27 of the Convention on Biodiversity, on the interpretation and application of that convention. And Your Excellency, with this, we pray to this Honorable Court, indeed, to find that the state of Nabotia has access and has consented to the jurisdiction of this Honorable Court. Furthermore, Your Excellency, as seen under paragraph 8 of the facts, indeed, it is clear that the state of Nabotia has made a revocation notice in regards to the United Nations Convention on Law of the Sea. We are not disputing the revocation. Indeed, pursuant to Article 287, the revocation is valid as three months has elapsed. And indeed, the acts before this Honorable Court happened in 2014. And the revocation notice, as seen under paragraph 8, was made on 1st June 2015. And the matter before this Honorable Court was brought by the applicant state on 4th June 2016. And indeed, 3 months has elapsed and the revocation notice is valid. However, Your Excellency, relying on the case of Rodo versus Trinidad, before the Inter-American Court on Human and People's Rights, indeed, this case is persuasive to this Honorable Court. However, we pray that this Honorable Court borrows the decision that was made in regards to the denunciation that was made by Rodo, by Trinidad. Your Excellency, the court noted that the denunciation by the state of Trinidad did not in any way affect the jurisdiction of the court for the acts that had happened prior to the denunciation. And Your Excellency, in the instant facts, it is clear that the state of Nabotia made a revocation notice after the acts had already happened. And with this, Your Excellency, we humbly pray to this Honorable Court that it should find that indeed it has the jurisdiction it has the powers to enjoin the state of Sakovia, and this court should withdraw jurisdiction if the state of Nabotia is not joined to this matter. Your Excellency, this drives me to the second head of argument in regards to the unitization agreement. Your Excellency, according to Jacqueline Weaver in the journal, pardon Your Excellency, according to Jacqueline Weaver in an article, pardon Your Excellency, according to Jacqueline Weaver in an article in the Austin Journal of International Law, Volume 28, Your Excellency, she defined a unitization agreement as a joint coordinated operation of oil or gas reservoir by all the owners of the rights in the separate tract overlying the reservoir. And Your Excellency, as seen under paragraph 8, pardon Your Excellency, as seen under paragraph 10 of the facts, indeed it is clear that the state of Nabotia and Himia entered into a unitization agreement in regards to the oil reserve that was discovered in the shared continental shelf. And Your Excellency, furthermore, paragraph 15 of the facts, Your Excellency, it is clear as to the content of the unitization agreement. If I may read in verbatim, Your Excellency, paragraph 15, line 4, from the diplomatic note that was sent back in reply to the state of Sakovia's claim, line 4, it states that the unitization agreement duly qualifies that damage and liability shall be shared between the two contracting parties in the event of an oil spill or damage of transboundary nature. And Your Excellency, indeed, the matter that the applicant state have brought before this Honorable Court is in regards to the oil spill, and they claim that there is transboundary harm. And Your Excellency, as in the unitization agreement, in case of any oil spill or transboundary harm, the liability shall be shared between the states. And if this court goes ahead to make a decision that this Honorable Court has a jurisdiction, if the state of Nabotia is not joined, by the powers that it has under Article 59 of the International Court of Justice, which is to the effect that this Honorable Court is not bound by its decision, but the decision binds the parties to the matter. Your Excellency, how then should we go ahead and ask for the state of Nabotia to pay part of the compensation that the state of Sokovia is asking for? With this, Your Excellency, we pray indeed that it should find in favor of the respondent that this Honorable Court should withdraw jurisdiction until the state of Nabotia is joined to this matter. Unless there are any other questions, I'd like to cede the floor to my co-agent.
Please, you can pass it on. Thank you.
Much obliged, Your Excellency. Your Excellencies, for record purpose, my name is Swale Hemed Wengo. I'll be responding to the applicant's submission regarding to the second and third issue respectively. Subject to the convenience of this Honorable Court, I'm ready to proceed. Your Excellencies, learned agent of the applicant made allegations before this Honorable Court without any proof. And it is important to note before this Honorable Court that as an officer of this Honorable Court, it is wrong and unethical for you to mislead the court. And Your Excellencies, with all due respect to learned agent of the applicant, he actually went ahead and misled this Honorable Court. First and foremost, Your Excellency, learned agent of the applicant argued that the respondent state has an obligation to conduct an environmental impact assessment pursuant to the provisions of the Convention on Biological Diversity 1992. And specifically, the provision that talks about environmental impact assessment under the 1992 Convention on Biological Diversity is Article 14 of that convention. And Your Excellencies, specifically Article 14 clearly states that states must, as far as appropriate and applicable, put procedures for conducting an environmental impact assessment when a plant activity is likely to cause adverse environmental effect on the biological diversity. A crucial point to note, Your Excellencies, in the provisions of Article 14 of the 1992 Convention on Biological Diversity is the word as far as appropriate or applicable. Your Excellency, this same position was reiterated in Article 206 of the 1982 United Nations Convention on the Law of the Sea. Specifically, it provides that states must, as far as practicable, assess the potential of an activity to cause effects to the marine environment when such activity is likely to cause substantial pollution or significant harmful changes to the marine environment. Now, Your Excellencies, Article 206 of the United Nations Convention on the Law of the Sea 1982 reiterate the word as far as practicable. And Your Excellencies, the International Tribunal for the Law of the Sea, specifically in the Mox plant case, it clearly provides that Article 206 of the United Nations Convention on the Law of the Sea, as well as Article 14 of the Convention on Biological Diversity, does not put an obligation upon a state, but gives a state the discretion of conducting an environmental impact assessment. Therefore, Your Excellency, the argument that the learned agent of the applicant averred that there is an obligation to conduct an environmental impact assessment was just but a mislead to this honorable court, because there is no obligation, but the provisions gives a discretion upon a state to conduct an environmental impact assessment. Secondly, Your Excellency, the question that the applicant did not address before this honorable court in regards to the environmental impact assessment is whether the activity that the respondent state conducted is an activity that requires an environmental impact assessment. And Your Excellency, pursuant to paragraph 11 of the fact sheet, it is clear that the respondent state conducted a marine seismic survey. And Your Excellency, to determine whether or not a marine seismic survey is an activity that requires an environmental impact assessment, Your Excellency, the respondent would like to borrow from one of the most outstanding conventions in matters to do with environmental impact assessment, specifically the Convention on Environmental Impact Assessment in Transboundary Context, which we shall hereinafter, Your Excellency, refer to it as the ESPO Convention. Now, Your Excellency, the ESPO Convention, specifically under Article 2, it provides that states shall conduct an environmental impact assessment when a plant activity is indicated under Appendix 1 of that convention, and it is an activity that is likely to cause adverse effect on the environment. Your Excellency, if we are to look at the first criteria that Article 2 of the ESPO Convention provides as to whether the marine seismic survey is an activity listed under Appendix 1 of the ESPO Convention, Your Excellency, marine seismic survey is not one of the activities mentioned under Appendix 1 of the ESPO Convention, and to that effect, Your Excellency, we can humbly submit that marine seismic survey is not one of the activities that require an environmental impact assessment. However, Your Excellency, we understand that learned agent of the applicant might come before this honorable court and rebut that accusation, basing that there is an activity under Appendix 1 listed as offshore hydrocarbon production, and they might argue that offshore hydrocarbon production is an activity that is inclusive of marine seismic survey. However, Your Excellency, the second amendment to Appendix 1 of the ESPO Convention clearly defines what offshore hydrocarbon production is. And it provides that offshore hydrocarbon production is the extraction of oil and gas for commercial purposes of 500 metric tons of petroleum and 500,000 metric tons of gas. And Your Excellencies, any activity that does not have even a single drop of extraction of oil and gas, that activity do not fall within the realm of offshore hydrocarbon production. Now, Your Excellencies, to determine whether or not marine seismic survey is an activity that has even a single drop of extraction of oil, it is crucial to understand what exactly a marine seismic survey is. And Your Excellencies, learned agent of the applicant did not address or clearly explain to this honorable court what a marine seismic survey is for it to amount to an activity that requires an environmental impact assessment. Now, Your Excellencies, a marine seismic survey is an activity that is conducted on water. And specifically, Your Excellencies, there is a vessel, which is not any kind of a vessel, but a special kind of a vessel that has a back-in. And the purpose of the back-in, Your Excellency, is to lay down a floating cable known as a streamer. And this floating cable has two things. First, it has something called an acoustic source. And secondly, it has certain kind of microphones known as hydrophones. Now, Your Excellencies, the function of the acoustic source is to send compressed air into the ocean, and it passes the sub-layers into the rocks, then it is reflected back to the hydrophones, where the hydrophones collect the data of the subsurface below the water body. Then, Your Excellency, that data is taken to a supercomputer so that it can be processed and filtered so as to remove any other sound, maybe, Your Excellencies, from the vessel that was conducting the marine seismic survey. And at that juncture, Your Excellencies, that data is converted into a 3D format where any geoscientist can read that data and determine whether or not that area has petroleum traps. Now, Your Excellencies, it is crucial to note that marine seismic survey is an activity that only determines whether or not an area has petroleum traps, and Your Excellencies, there is not even a single drop of extraction of petroleum, therefore it cannot fall within the realm of offshore hydrocarbon production under Appendix 1 of the ESPO Convention. And to that effect, Your Excellency, marine seismic survey is not an activity that requires an environmental impact assessment. Your Excellencies, moving on to the second issue in regards to transboundary harm, whether marine seismic survey is an activity that would cause transboundary harm. Your Excellency, first and foremost, it is crucial to note that learned agent of the applicant addressed this honorable court that marine seismic survey, as well as the oil spillage that happened in the Sedna Sea, was the reason behind the death of the Hawksbill turtles. And Your Excellency, first and foremost, learned agent of the applicant established the no harm principle that states have an obligation to make sure that its activity do not cause harm to the territory of another state. And they relied on the Trust Smelter case of 1941, specifically between the United States versus Canada. However, Your Excellencies, what learned agent of the applicant did not address and tell this honorable court that in the same case of trial smelter between United States versus Canada, this honorable court went ahead and said only when a state has established that another state has caused transboundary harm, then at that juncture, that state can be held liable for that transboundary harm. And secondly, Your Excellencies, Judge Sue Hanquin, who is one of the learned judge of this honorable court, specifically in her article, Transboundary Damage in International Law of 2003, he goes ahead and says that there must be a direct causal link between the damage that was caused and the activity that was conducted in the area that is said to have caused the damage. And Your Excellencies, what learned agent of the applicants have not been able to establish before this honorable court is the direct link between the death of the Hawksbill turtles to the marine seismic survey or to the oil spillage that happened in the Sedna Sea. Your Excellency, the Reefers Institute of the applicant state went on to do a research to determine the death of those Hawksbill turtles. However, that research was inconclusive. And to that effect, Your Excellencies, there is no link between the death of the Hawksbill turtle to the applicant, to the activity conducted by the respondent state. Your Excellencies, even the diplomatic note under paragraph 13 that the applicant sent to the respondent state, it clearly states, Your Excellencies, specifically under line 4, that they are taking into consideration that the actions by the respondent state may have contributed to the death of the 9 Hawksbill turtles. They are using the word may have. Your Excellencies, even the applicants themselves, through the diplomatic note sent to the respondent state, they are not sure whether or not the activities conducted by the respondent state are the ones that caused the death of the Hawksbill turtles. Your Excellencies, in 2009, there was a workshop of the ISC Regional Hawksbill Turtles Workshop held in Puerto Morales, Mexico. And specifically in this workshop, they came up with a report of the most highest threats to the Hawksbill turtles population. And specifically they said, the lack of community collaboration incentives for conservation and the change of open ocean conditions, such as temperature, are the most ranked highest threats to the Hawksbill turtles population. Your Excellencies, any of these highest threats could have been the cause of the death of the Hawksbill turtles and not the activities conducted by the respondent states. Because even the research institute that the applicant state had put specifically on matters to do with the Hawksbill turtles could not come with a conclusive evidence that the death of the Hawksbill turtles was caused by the respondent states. Furthermore, Your Excellencies, learned agent of the applicant argued before this honorable court that the respondent state should pay compensation for the damage caused. Your Excellency, if I'm to rely on the International Law Commission's Articles on State Responsibility, specifically under Article 34, it provides that a state shall pay full reparation for the damage caused when a state has been said to have caused the damage to another state. Your Excellencies, in these provisions, it is clear that only at a time when a state has been able to establish that another state has caused damage, that is when a state will be required to make full reparation. Your Excellencies, learned agent of the applicant have not been able to substantiate before this honorable court that the respondent state are the ones who went ahead and caused damage. Therefore, I'm asking this honorable court and even the learned agent of the applicant, to what extent do they want the respondent state to pay for compensation when they have not been able to substantiate that the respondent state is the one that caused damage? Your Excellencies, even if we are to assume that they have been able to establish that the respondent state is the one that caused damage, Your Excellencies, learned agent of the applicant are not telling this honorable court how much compensation should the respondent state pay to the applicant state. Furthermore, Your Excellency, learned agent of the applicant argued that this honorable court should order that the activities that are conducted by the respondent state, they should be halted. Your Excellencies, it is crucial to note that the International Law Commission's Articles on State Responsibility, specifically under Article 30 to 31, as well as Article 35 to 37, they provide where a state has gone ahead and caused transboundary harm to the applicant state, and it has been established, so three conditions arise. First, three obligations arise, sorry, Your Excellency. The first obligation is that the activity should be discontinued. The second obligation is that there must be a guarantee of non-repetition. And lastly, Your Excellency, there is an obligation for a state to make full reparation for the damage caused. Now, Your Excellency, the obligation to discontinue an activity only relies where that activity has been proved to be the activity that caused the damage to the territory of another state. And Your Excellencies, the onus is on the applicant state to prove before this honorable court that the respondent state went ahead and caused transboundary harm. However, Your Excellencies, the applicant have failed to show the burden before this honorable court that the respondent state really did cause transboundary harm. And to that effect, Your Excellencies, we humbly pray before this honorable court that this honorable court should not order the respondent state to go ahead and halt the activity that it has been conducting within its jurisdiction for the purpose of oil and gas extraction. Further, Your Excellencies, learned agent of the applicant went ahead and argued that by virtue of paragraph 2, that they depend mostly on ecotourism, and the death of the Hawksby turtles affects them, specifically their marine protected area. However, what they did not tell this honorable court is that the same paragraph 2 talks about that the respondent state also depends heavily on tourism and turtle sea watching. Your Excellencies, the Sedna Sea is shared among the three states, the state of Sokovia, Himia, and Nabotia. And Your Excellencies, the Hawksby turtles are known in that area. And to that extent, Your Excellencies, no state can claim that the Hawksby turtles are their property, specifically being categorized as migratory species. And to that effect, Your Excellencies, even the applicant state is a state that heavily depends on the Hawksby turtles. And Your Excellencies, that's why under paragraph 11 of the fact sheet, the respondent state went ahead and put measures in order to make sure that the Hawksby turtles population is not affected. Your Excellencies, the respondent state went on and put a turtle spotters and ramping up process. Your Excellencies, the ramping up process was a process that, as per paragraph 11, it was meant to make sure that the Hawksby turtles leave the area and do not come close to that area, so as to make sure that they are not affected. To that extent, Your Excellencies, the applicant state cannot humbly submit before this honorable court that the respondent state is the one that caused damage to the territory of the applicant state as well as to the death of the Hawksby turtles population. Your Excellencies, lastly, I would like to submit on the question that the activities conducted, in this case, they were activities only conducted by the respondent state and the state of Nabotia should not be joined. Your Excellencies, as my learned colleague, Ms. Chitindi Marvelous, has been able to establish before this Honorable Court what exactly a unitization agreement is. Your Excellencies, in matters to do with oil and gas, there is two different things. First, there is a unitization agreement, and then there is a joint development agreement. What learned agent of the applicant submits before this Honorable Court is a question of a joint development agreement. Your Excellencies, the difference between the two agreements, a unitization agreement, it is between states that have a shared resource, and any of the states can go ahead and do the extraction. However, the two states will share the profits and the loss of that extraction. However, in a joint development, both the two states must conduct the activity together, taking into consideration that there was a shared resource, there was a shared continental shelf. And Your Excellencies, it is important to note that under Article 55 as well as Article 76, both the continental shelf and the exclusive economic zone are calculated by taking into consideration the 200 nautical miles from the baseline. And Your Excellency, we understand that the continental shelf can extend beyond 200 nautical miles, but not more than 350 nautical miles. And Your Excellencies, taking into consideration paragraph 2 of the facts, it is clear that the exclusive... Your Excellencies, I'm asking for 1 minute to conclude.
You may have 1 minute.
Much obliged, Your Excellency. Your Excellencies, taking into consideration that the exclusive economic zone of the respondent state, of the state of Nabotia, is bordering the marine protected area of the state of Himia. And Your Excellencies, that marine protected area is half of the respondent state exclusive economic zone, telling you that the exclusive economic zone of Nabotia and exclusive economic zone of the respondent state are at a different place, calculated with 200 nautical miles from their baseline. However, they are saying that the continental shelf is shared between the two states, a clear indication that the shared continental shelf has been calculated to extend beyond 200 nautical miles. To that extent, Your Excellencies, the continental shelf of the state of Nabotia has extended beyond 200 nautical miles into the exclusive economic zone of the respondent states, and to that juncture they have a shared continental shelf. However, the same place where the shared continental shelf is the same place where the exclusive economic zone of the respondent state is calculated with the 200 nautical miles. And to that effect, the activities conducted in the exclusive economic zone are at the same place where the shared continental shelf is, and therefore the unitization agreement will apply to both the two states because it was in regards to the shared continental shelf. Your Excellencies, if there are no further questions, I'm thankful, and we as the respondent are resting our case.
Thank you very much. There are no questions. So this brings us to an end. Thank you very much.
Your Excellencies, if I may.
Guide you a little bit so we don't take too much time. Could you please just kindly respond to issues of discretion with regards to the EIA, the impact assessment, the seismic survey? I think those were the most important issues. Transboundary harm, you gave us the Canadian case, you gave us a different version. Link, I think there's the oil spillage and the death of the turtles. You couldn't really establish whether or not it was caused by them. Which was inconclusive. The issue of compensation, how much are you asking for? You didn't tell us. And then lastly, the issue of activities, whether or not they ought to hold the activities. Give us reasons, cogent reasons for that. Thank you.
Thank you, Your Excellencies. I was rising on my feet to exactly, and you read my mind, rightly so. Your Excellencies, if I may first tackle this court, the hue of this court, Your Excellency. Hawksbill turtles don't own passports. they walk, they swim free back and forth into the state of the respondent, into the water of the respondent, and equally back to the applicant state. Your Excellencies, in our opening statement, we asked this court, why should we set on a path of self-destruction? We equally noted, Your Excellencies, that the parties before you today have an economic backbone resting on ecotourism. We noted that. And it is not right for the agent the other side to state that you did not take cognizance of that bit. We did. But then, let me answer to the questions raised by this very bench. Mr. President and Your Excellencies, the question on environmental impact assessment. It is a settled position in law now. Your brother judges and sisters sitting in the pulp mills case, Your Excellencies, we are also alive to Article 59, to the fact that it is the decisions of this court are only binding to the parties before it. But it is persuasive, and for judicial consistencies, we will be praying that this court adopts that position. In the pulp mills case, Your Excellencies, it was stated that an environmental impact assessment must be conducted particularly in potential transboundary harm. If potential transboundary harm is likely to occur, and if there is a shared resource. Your Excellencies, is there a shared resource? The Sydney Sea is a shared resource. And to that end, there was need to conduct environmental impact assessment. Your Excellencies, I've allowed the respondent agent explaining to this court that we did conduct a seismic survey. What is the purpose of a seismic survey? To find out if there is an oil deposit. That is the essence. They state that they put up turtle spotters. Very okay. They equally say that they increased the ramping up of sound. Perfect. But the question is, was it sufficient? Having the fact that the drilling was only 3 kilometers away, was there an obligation that was heightened? Yes. That obligation was one to ensure that their acts does not cause transboundary harm. Was there anything in the minds of the respondent to make them believe that there might be harm? Yes, and that is why they had the turtle spotters. And that is why they had the ramping of sounds. But nevertheless, even with that fear, Your Excellencies, they went ahead to contract an inexperienced corporation. What was the result? A catastrophic oil spillage. Your Excellencies, we do not argue about the seismic survey. The issue is on the oil spillage that has caused a diverse effect to the environment. Your Excellency, the question next is on the issue of whether there is a causal link. Your Excellency, there is a causal link. The respondent stated what are the likely threats to the hawksbill turtles. But they failed to mention one thing. That one thing is pollution. What is the effect of pollution? If Your Excellency were to take a walk today in the streets and a vehicle that emitted carbon passed next to you, you will be choking. What is the effect of an oil spillage? It equally interferes with the oxygen depth in the waters. The turtles breathe that very oxygen. It is a causal effect, and it is linked thereto. Yes, they referred us to paragraph 13, but Your Excellency, what they failed to also consider, paragraph 8, read in paragraph 13, will show this court that it was only barely after 22 days when the process of extraction started, the turtles were found at our shores. Your Excellencies, they've equally stated and read, they're not verbal, but they did fail to one thing. Paragraph 16 speaks, Your Excellencies, the bailiff tells me that I'm out of time. I will only require just but few minutes to make my
I'll
conclusion.
give you 1 minute.
Thank you, Your Excellency, most obliged. Your Excellency, paragraph 16. The parties were advised to conduct a further investigation. And in that very paragraph, if I may read verbatim, and I'll only pick that very part, which investigated and advised the parties on the likelihood of further significant transboundary harm. Was there harm caused? There was. Your Excellencies, what are we saying? We cannot quantify the cause. We cannot quantify the cost. But then we'll put a figure. Because in any case, we cannot go back to where we were. The environment has been affected. Your Excellencies will be asking this court to find that it has jurisdiction, to find that there was no due diligence conducted, and to find that indeed the respondent state is liable to pay. And we will be asking this court on a basic principle, sum. If I'm to quote Your Excellencies, in the Kenyan position, they say that a barrel of oil is equal to 4 barrels of water. That is as per the project that is going on in Turkana. If I'm to quantify a barrel of oil, Your Excellency, I'm not an expert in oil, but then it is in the sums of it. And the respondent state, since they want to flex the muscles into that other sphere, will be saying that a figure of $1 million will be but sufficient to help us cure the menace at the sea. Your Excellencies, we implore this court that we have to save a generation, the generation today, and the generation not yet seen. And as per the summit at the South African, Your Excellency, in Joburg, the question that was how far can we exploit? How far can we do it? We have to consider today's generation and that of the future. Your Excellencies, find that you have jurisdiction and do dismiss the objection that has been raised by the respondent. I seek to cede the ground.
Thank you very much indeed. That
Thank you,
brings us to the very end of this debate. Thank you.
Ladies and gentlemen, which one of these you got to be? The judge's seat or the lawyer's seat? At this point in time,
We have a round of applause for this. By show of the Moot Court competition that I had announced earlier, 2 teams emerged to be outstanding. Those were Kampala International University and the Kenya School of Law. As I shed a tear for Strathmore, and I punch for Kampala and Kenya School of Law. But really, there were no losers. You've seen the quality of the arguments here. So you can imagine where they came from and the people they're competing against. And I was asked to clarify why the judges are being referred to as Your Excellency. This was simulation before the International Court of Justice. That's what we call them there. And if you noticed, we also had gender balance across both teams. That was very deliberate. Asante sana. We challenged the teams to think about balancing in terms of gender. And at this point in time, really, I'd like to call upon the Dean of the Strathmore Law School, Dr. Louis Franceschi.
You know, I'm in this room and I feel still like a student because I have my teacher and supervisor, Justice J.B. Ojuan, sitting here. And I remember something interesting that happened many years ago when I went into his office in Parklands and I did not know what to write about, and he did not say much, but he gave me a dissertation from an LLB student, a girl, told me, read this, nothing else. And I went, I don't know if you remember, Prof, but I went and I read that dissertation, and it became somehow very clear to me what I wanted to write about. And this is the way he did it 20 years ago, and this is the way somehow we try to do things here at Strathmore. we have not pushed any of our students, we have not pushed any of the visiting students to do this, but we simply gave you this moot competition that Extractive Barasa, the Strathmore Extractive Industry Center, SAIC, Extractive Industry Center have put together, the Strathmore Law School, and gave that moot to students. And students went and prepared. Many of you went and prepared your arguments, your presentation, etc. And that has given you a new horizon, opened incredible doors to discover, hey, there are serious problems and challenges with extractive industries in Africa, and we always have to call the expert from outside to come and resolve them for us. And then, of course, and that comes at a fee. So shouldn't we try to look at the problems and try to see where we can get advice? We will, but we are resolving our own problems. You know, I shouldn't say this here because I'm being recorded and it's politically incorrect, but the remarks President Trump mentioned a few days ago or a week ago will trigger an incredible forest fire, you see, in the whole world with what has he said. But you see, I don't excuse him and I don't justify that, but certainly, is he saying what many times we think but we don't dare to say? Is he telling us what many people think but maybe, I don't know, international organizations usually call less developed countries or least developed countries? Because in the end, comes practically to the same thing, and it shouldn't be. So I think more than we can criticize him and keep him making quiet because it's an insulting remark if he really said it, but we have to reflect and think, hey, how can I change this? How can we be those agents of change who will really take our own problems into our hands and resolve them? And I think that is a great challenge. So in a way, it's what a good teacher did with me 20 years ago, and it's what this moot competition, spearheaded by Melba and her team, has tried to do today. And I hope the moot will not die with the prize giving, but the interest that has been triggered in you will come to a very good conclusion. I was talking to somebody at the entrance, and with this I will finish, and I was mentioning, look, I was taken to visit the tunnel being dug through Gong Hills for the SGR to reach Naivasha and subsequently Kigali. And it struck me the similarity between the SGR being built in 2018 and the British locomotive or rail that was built at the end of the 19th century. Because there is a huge similarity. I think this railway is just passing through Kenya because there is a much more interesting deposit of minerals, etc., on the other side, beyond Kigali, in Congo, and could be a way of reaching Congo, and hey, let's exploit this. Of course, it brings us development, and it's a very good thing. But you say, well, hey, wait a minute, are we aware of all the aspects of this exploitation, what is happening? I mean, how things are developing around us, or are we still like our elder Maasai brothers, for example, were when the railway was passing through them in the 19th century and they did not know what this serpent is all about? Well, I think it's a call for us to be more involved, to be more aware, and to really see the responsibility education gives us in our development and the needs of our countries and all the countries in East Africa. Well, I have spoken for too long. I'm only in page 45. Thank you very much. Thank you, Marcela, for being here. Very supporting, and the Attorney General who sent you, we thank him for that. And Justice Ojuang, we don't take for granted that a Supreme Court judge should come here to judge students. And we thank you all. Thank you very much.
Thank you so much, Dean. And in all honesty, Justice Ojuang, we just miss seeing your face. We've been seeing it so much that we had to remind people. Ladies and gentlemen, we now want to go into the prize giving ceremony. So could I kindly ask the following persons to come so that they can be able to give the hands photograph moment. Please, this is when you tweet them, surely. Can we give them their moment in the sun? Our hashtag is KE Annual Baraza. KE Annual Baraza, please. They worked very hard on their memorials. They did a fantastic job. And of course, photo op. Thank you so much. Then, when the orals began in the last 2 days, out of the 12 schools, we identified 2 students who have amazing oratory skills. The ones who even convinced the non-lawyers in this room to pay attention to what they were saying. One is, so we're going to give the best female oralist, is Anne Njoroge from Kenyatta University Law School. So KU didn't make it to the finals, but she did an outstanding job. Ladies and gentlemen, you don't get better interns than these. The Baraza connects. She's come here twice. Can somebody just tell her, I need to talk to you to come to me to give her a position or something? That is why we have the Baraza. Take note. Her name is Anne Njoroge from Kenyatta University Law School. The best male oralist is Kevin Kokobe. Thank you, Kevin. Kevin is from Kenya School of Law, Kokebe. Kevin Kokebe. And most of us saw him this morning. Are we in agreement? He managed to convince you about what big terms were those? But he did an outstanding job. Thank you so much. And now we want to thank the runners-up, the teams. Now we're getting into the teams. And the runners-up, for this, they did a good job. Remember, we were 2 universities and competed against each other. And the results are in, ladies and gentlemen. Can we have Chitindi Marvelous and Swaleh Wegom Hemed from Kampala International University? Thank you so much for your contributions. And yes, it looks like the applicants did prove their case. Asanteni sana. And that means the winners should be preparing. That, you know how when every lawyer that stood up was doing like this, the suit. Please, can we see that motion again? Some photographs, please, of the runners-up. Fantastic job. Thank you so much. And ladies and gentlemen, to announce the winners of the first Extractives Baraza Moot Court competition. We have Eva Maria Anyango and Kokebe Kevin from the Kenya School of Law. Just imagine the confetti falling. Yeah, go ahead. Thank you so much. Makofi tafadhali. Maricela, if you can hold on to that trophy together with Justice Ojuang. Hey, you know this is a moment to capture for your legal profession. This one you put it on your CV. The photograph needs to appear. These days CVs are digital, ladies and gentlemen. The winners from the Kenya School of Law who have done a tremendous job. And as they're taking their photographs, we'd like to acknowledge our platinum sponsor, UK Aid, that enabled all this to happen. We'd like to acknowledge our silver sponsors, Oraro Law Firm and Natural Justice and Base Titanium. And we'd like to acknowledge our bronze sponsors, East Africa Law Society, Oseko and Ouma Advocates, the ALSF,